Yeti krom ha ena Madam Toko no Supreme Court eba abontin beka say a final ruling on the vacant seat issue. Na ruling now ban say 5 against 2. There's a judges need to say yes real. Judges need to say bag maintain and judges need so 5 to say yen san free MPs ne back to parliament until enu na free 5 against 2. Now sa ruling no eba abonte no omanfo bebre ayeden akasa yi eno na Sam George akotena TV so a o kire say ono dia dinkan Canada say asa akwakoye say under this administration no the judiciary is always at the side of the executive and I say the MPP ti ono Sam George say Chief Justice nim say oyo ba rule now are making on Wambra Parliament and conduct government business na yenhwe and Sam George atutu amane ne de edoso moment.
Thank you. Listen, the Chief Justice is overstepping her powers and is bordering on abuse of her powers under Article 296. She's being arbitrary and capricious and malicious in the use of her powers, usurping the powers of her own lower courts, the high courts, and then seeking to tell Parliament what to do. And that's why I have said that if the Chief Justice thinks she's so vested with so much power, she should come and sit in Parliament, convene Parliament, and go ahead and conduct government business for them. But you see, the Chief Justice must know, like the Speaker said, that we do not respect the supremacy of the Supreme Court. We respect the supremacy of the Constitution. The Supreme Court has no supremacy over the Parliament of Ghana. And you see, it pains me that members of Parliament are complicit in this rape of the powers of Parliament, because today it serves their partisan parochial whims and caprices. And that members of Parliament, Echo, you know, and Afenumaki knows, that look, to challenge a ruling or directive of Mr. Speaker, our standing orders give you a fantastic opportunity to come under a substantive motion. So today, you are telling me that every time any member is unhappy with a ruling of the Speaker,
which ruling
we will go away from our standing orders and run to our godmother sitting at the Supreme Court to give a ruling and say, look, then the Supreme Court should be ready to cite all members of Parliament on the majority NDC side for contempt. You must be ready to cite 136 of us for contempt and cite Mr. Speaker for contempt. But let me serve notice already that I have summoned the head of the Association of Magistrates and Judges. What's his name again? He's one of the new judges that was approved recently by Parliament.
You summoned him for what?
I've cited him for contempt of Parliament because he held a press conference and told a blatant lie. Unbecoming that a member of Parliament, because he didn't mention my name, he says a member of Parliament led a mob to the Supreme Court seeking to invade the Supreme Court and heap invectives. He must come before Parliament, our Privileges Committee, and establish for us which member of Parliament carried out such action. Because I led a group of clergymen to the Supreme Court to demand action of the Chief Justice, who has been sleeping on the LGBTQ case. The Chief Justice has become a cog in the wheel of justice. The same Chief Justice, a matter involving Parliament and the usurpation of the powers of Parliament under Article 106. The Chief Justice has now become a cog in the wheel of justice, standing against the wheels of justice grinding, and is playing ball to help the president evade service. I mean, look, it is a shame, it's an aberration, and like Justice Amadou Tanko stated, I hope that in the nearest future, a properly constituted Supreme Court would vacate this ruling, which is a stain on Ghana's legal jurisprudence. Look, any judge worth his sort or any law student anywhere in the world who picks this majority ruling would have a good laugh at the Supreme Court of Ghana. And it's a shame that such a court that has such distinguished personality, and that's the point. In 1 minute, that's the point. That's 10 seconds. That's the point. That's the point Martin was making. That you've got fantastic lawyers, Justice Poman, Justice Bafo-Boni, Yoni Kolendi. There's a reason why such reasoned and detailed and seasoned legal minds were kept away from this. So, they will not, look, for any consideration, bring themselves down to this unfortunate ruling.
What is the status?
So you see, Sam George, no. Me, Anka Supreme Court, AN ruling, no. I don't have any problem with that. Nanka Supreme Court AN Ajumano, ka me no problem. But the problem is there are more cases in that same court critical to investigate, to talk about, to make judgment than this Parliament case. South of us, saying up till now, we need representation of Parliament. Just say, Chrome had here, say government institution be ye na adwuma na akọ aye it must go in favor of what? The party in power. Say enko in favor of party in power emfa. And can imagine saying ka constituency no. South constituency no kay Western region na ye tia free man. Ka Supreme Court bet na asem so. Just imagine no. Mo am say we are politicizing everything no. Ask yourself. Say kay Western region ka Supreme Court bet na asem so. Kay Ashanti region ka Supreme Court bet na asem so. Just ask yourself. Eastern regional ka Supreme Court ebet na sa asem so. Yentina so. Kaya make ruling long time. Ama ya yeden ya chese ya tu abayi MP amawa beka omo. But womunim say constituency ni yetia NDC be win ntino yenye yatena so. Yenye ruling ema yenka say akwa government ni favor and decide yetena so yenka ho asem. Ile case ni the same thing. Trumu bill asem no eno so da ho. We ye judiciary ye kan na nkrofo edi atem. Signing bill say Uganda president ye Museveni ye say ye musuo wo na country mu no sign it member ye mra na ye ntwa sankwase ade no so no up till now mampanyin timin sign ye at the Supreme Court. How do you convince me say menji judiciary dindi under this regime and Akufo-Addo and Bawumia you want me to trust Supreme Court? Obu me say Sam George na mutiri nkano